never said I got my order, I did it. Well, so did they, all the little guys. They got their order and they did it.
Well, Himmler visited Auschwitz, didn't he?
Huh?
Himmler visited Auschwitz.
Yes, of course.
They have nice chicken.
1942 he came over there.
Yeah, but they have nice chicken dinner that night.
Yeah, chicken dinner didn't bother him. He looked through the through the peephole, let the people die. Yes.
I think you can. I'm not making jump.
But I have to feel
Yeah, I need to develop
Most of you are from the conference at Chautauqua, and it's our real privilege to have you here at the Jackson Center so you get a sense of who we are and what we're doing, and we really greatly appreciate you taking the effort to make it to this conference. I'm going to just take a couple minutes to acknowledge a few people. We had several sponsors, corporate sponsors, and individuals who helped us with the finances for this conference. And I wanted to, they're not all here tonight. I'm going to mention the three that are here. And by the way, as you leave tonight, there's a board out there, a sponsors board, and we gratefully recognize those who helped us make this happen. But there are three here tonight. I believe that, and if the fourth is here, my wife will tell me. Anyway, from HSBC Bank, Janice Burkhouse and Ellen Leskoviak, they're here. Are they still here tonight? The Chautauqua County Industrial Development Agency is represented by their Executive Director, Rich Alexander, and his wife, Jill. And then our own Warren and Betty Erickson helped us sponsor this tonight. And they're here. So we thank our sponsors, and we couldn't do it without you, and many, many thanks. I wanted to, I'll undoubtedly miss some of our volunteers, but the Jackson Center, we have 3 employees. We're all part-time, believe it or not. Greg Peterson makes us full-time, however. But don't attack him. We love it, okay? But our volunteers really make this place run, and 3 of the docents who gave you tours tonight are here, Fran Galbato, Steve Massa, and Jim Oria. I think we ought to thank them. There's also an unsung hero. I just saw her. She's probably ducked out so she can't be recognized, but all these flight reservations and all those kind of logistics, she's worked very hard on it. Jackie Shannon. She's back here. Finally, Greg's going to do more of the introductions of our keynote speaker tonight, but it's a great privilege for me tonight to bring to the podium once again someone who's a great friend of the Jackson Center, who's been a great friend of establishing and pushing forward the legacy of Justice Robert H. Jackson. Last year, through his generosity, we were able to publish a book that he wrote called The Tragedy of War, which you may have seen up at the Athenaeum Hotel. And I wanted to say that tonight, through his generosity, the Jackson Center has been able to publish a book that he worked hard on this year. It's a book about Rudolf Höss, the Commandant at Auschwitz. And Whitney Harris has entitled this book Murdered by the Millions. And we are going to bring Whitney up here just a second. But I wanted to recognize Jim Oria again, who helped do some proofwriting on this book. I wanted to recognize Charlene Peterson, who's here, who typed the manuscript for the print shop. She's here somewhere, aren't you, Charlene? There, up in the middle. Thank you very much. And the person that I'd like to have come forward to present the first book, and by the way, when you leave tonight, underneath that tablecloth over there is a book for each and every one of you, as a gift from Whitney Harris and the Jackson Center for being here tonight. And those of you at Chautauqua, I'm sure can grab Whitney tomorrow and get him to sign it. Those of you who are not at Chautauqua might want to try and grab Whitney tonight before he leaves, but I'm sure he'd be very happy to sign copies of this book. But the person here at the Jackson Center who worked long and hard on this is our Eugene Gerhardt scholar, who's with us for a year, a recent graduate of Princeton University, who's been putting tons of new material on our website, getting the permission of law reviews and publishing houses to put works by and about Robert Jackson on our website. And he worked very hard with Whitney on several drafts of this manuscript. And I'd like him to present Whitney Harris with the first official copy from the Jackson Center, Eric Larson, if you would come forward.
Yes, Mr. Harris, please come forward. I just want to thank Mr. Harris for giving me the opportunity to work with him on this book. It was a labor of love, it really was. And I have the privilege and honor of presenting him with the first copy.
Well, Eric, where could a writer succeed without a stalwart like this guy, Eric? And he's smart, too, and he made so many corrections to this little book. I'll tell you how this book got published.
Now, before you tell him, I'm just going to say, Whitney, it's great to have you here again, and thanks for doing this.
Oh, I'm not going to take any time from Christoph. We're here to, but anyway, when after the Nuremberg trial, I went up to Berlin. I was on General Clay's staff in Berlin, the head of legal advice branch. Came home, and I said, as a professor of law, got to write a book about Nuremberg. It's got to be made of record, and I did write Tyranny on Trial, and that was really a great book. And Justice Jackson, of course, wrote the introduction to it, the last thing he wrote in his lifetime. When that was done, I said, I'm forgetting Nuremberg completely. I don't want any more thought about Nuremberg in my mind. And this went on for many, many years. I didn't think about it at all. Then I recall that during the course of the trial, I had been responsible for presenting to the tribunal the affidavit which I took of Rudolf Höss, which was a commandant of Auschwitz concentration camp. And Rudolf Höss had told me in personal conversation across the table that 2.5 million people had been murdered at Auschwitz concentration camp. And this, you know, was the key piece of evidence of the Holocaust. And so I knew that he had made a confession to the British who captured him first, and I was able to get a copy of that confession, which was very dynamic. And I had his confession, which he told me. And then after Nuremberg, we sent him back to Warsaw, and he was tried at Warsaw and convicted by the High Tribunal of Warsaw and eventually hung at Auschwitz. What we didn't have of record then was the transcript of the trial of Rudolf Höss at Warsaw. So I went to Poland, and I had some friends there, and transcribed, and I set it aside. It was on tape, and the tape gradually deteriorated a little bit. So in the last few years, I got back on it, and I got finally got that transcribed. And so now I have the complete story. We have the complete story of Rudolf Hirsch, the greatest killer of mankind, the murderer of millions. And because of Eric and all my pals up here, we got it published. So that's the story of that. Thank you.
Outside the United Nations, there's probably no more greater talent in one place at one time than here tonight. So we thank one and all for making an extra effort for this, coming to the symposium, coming here tonight. And we're glad tonight to share a little bit about the Robert H. Jackson Center is about, you know, from a sense of mission and strategic planning, but also, you know, there is a facility. So we're glad you can come down, hold it, touch it, and see that we are for real. Tonight's guest speaker is Dr. Christoph Safferling. He studied law in Munich and London. He is an assistant professor in the Institute for Criminal Law, Criminal Procedure, and Criminology in the law faculty of the Friedrich Alexander University at Erlangen, Nuremberg, in Germany. He has been involved as a legal advisor to the claimants in several class action proceedings concerning compensation for forced labor during the Nazi regime. Apart from his doctoral thesis, entitled Towards an International Criminal Procedure, he wrote several articles on criminal law, public international law, international criminal law, European law, and comparative law. He is co-editor of the German Law Journal and the International Review of Criminal Law. At the moment, he is working on an habilitation thesis on intention and culpability with a view towards harmonizing criminal laws in Europe. Before I bring him forward, our connection with the Jackson Center, John Barrett, who is the Elizabeth S. Linné Fellow of the Robert H. Jackson Center and who will be speaking tomorrow afternoon and may be coming in any minute. And I had a chance to go to Nuremberg, and I trust most of you have had that chance. If not, for folks that are in the Robert H. Jackson business, it was riveting. And an opportunity to be in the courtroom, an opportunity to go to the Nazi rally grounds, to walk the steps of Robert Jackson during that time period. Well, our host throughout that time period was Dr. Christoph Safferling, and impressed us not only with his abilities and his background, but his enthusiasm. And he's really quite well thought of as in Germany and on the subject of the Nuremberg trials and the German perspective. So I look forward to hearing Dr. Christoph Safferling as he imparts his thoughts tonight to us. Dr. Safferling, please.
Thank you very much, Craig, for this extremely kind introduction. Thank you all for having me here. And when I look around, I'm astonished. This theater, this wonderful theater, and this wonderful Robert Jackson Center. And to have so many faces here, which I can't see really because I'm a bit blinded. But nevertheless, I can just imagine how many of you are out there. I feel extremely honored that you are having me here, that we come together as friends 60 years after the trials to remember together and keep a memory alive for the good cause of creating a better and a safer world. Thank you for letting me participate. I can only speculate why you actually chose me as a person to be here. Greg has just pointed out to you one of the reasons. I take it because I met you and John in Nuremberg when you came to visit the courthouse in January last year. Another reason is probably that I'm coming from the University of Erlangen-Nuremberg, and one would expect maybe that there is a Nuremberg trial scholarship just at the affiliated university. This is a nice guess, but it actually has never been true. Just until recently, we have Professor Klaus Kastner, and then in all my humble thoughts, myself, who are actually looking into the Nuremberg legacy and into the Nuremberg trials. The University of Erlangen-Nuremberg itself hasn't had a history of looking into that issue. What strikes me, nevertheless, is that you chose me as a speaker, whereas, as you can all see, I'm fairly young. And I would have expected that you want some experienced and wise German law professor to stand here before you and exchange his thoughts with you. But there we are, right in the middle of the topic, of the theme of this evening, the German perspective. The German perspective on Nuremberg and its legacy. The German view has changed over the last 10 or 15 years, which is due in part also to a change in generation. Invite a youngster like me, and you get a completely different view, and maybe a view which is more directed to the future. Let me give you two examples. William G. Griever, who lived from 1911 to 2000, a German diplomat and scholar who left us his grand volume, The Epochs of International Law, that was actually published, translated into English in the year 2000. And he wrote in 1985, hopes and expectations that were nourished in 1945 and the subsequent year, and inspired by the models of the International Military Tribunals of Nuremberg and Tokyo, were illusory from the very beginning. These models could only impress zealots and starry-eyed idealists who were blind or dazzled by the realities of world politics. In contrast, I hear protesters out there. I would protest to this as well. And in contrast to that view, Hans-Peter Cowell, also a German diplomat and now the German judge at the ICC, stated in an interview in 2003, the Nuremberg trials have initiated a process that is irreversible, and at the end of which now stands the International Criminal Court. There are not even 20 years in between these comments of two German scholars and diplomats, and they couldn't be more antagonistic. But let me start from the beginning. I will say a few words on the reception of the Nuremberg trials as they were in Germany, held in the immediate aftermath of the trials and during the trials. My second point will be the phase after the Federal Republic of Germany was founded, and I need to see also a few words on the reception of the trials in the Soviet-occupied zone. My third point is the time after unification in 1990. There was another swing with a sudden rise of international criminal law through the establishing of the ad hoc tribunals. Lastly, I will say a few personal words on the legacy of Nuremberg. The German public wasn't anywhere near closely following the trials in Nuremberg. This had several reasons. First of all, the Germans were primarily busy with organizing everyday life. Everything was destroyed. They needed to find food for the next day. That was their primary issue. Secondly, there also was a considerable amount of anger amongst the population on these Nazi leaders that were actually accused. They were just seen as guilty for this disastrous situation every German found himself in, and a total collapse of civilization, so that they actually deserved punishment. Looking at polls stemming from 1947, around 80% of the German population thought the Nuremberg trials were actually just and fair. A mere 6% were critical, and some 9% thought the judgments were too hard. The German academia, on the other side, avoided to address the trials altogether. There was a general sentiment that it was politically unwise to address the trials, in particular in a critical manner. And let me say that to you, one would expect the German academia to be rather sensitive towards political opportunism. With all necessary caution, I might say here that many law professors in the 1930s knew exactly what the Nazi Party wanted to hear and wrote accordingly, hoping to receive swift promotion in their careers. Think of the so-called Kieler Schule, where in the early 1930s, young law professors made Nazi ideology and legal dogmatic go hand in hand at the University of Kiel in North Germany. Now, in 1946 and the subsequent years, the denazification process was underway, so you'd rather shut up. From 1950 onwards, the situation changed dramatically. The polling situation now, and Michael Schaaf was giving us, I think, these numbers in his presentation this morning. At the beginning of the 1950s, the polling situation was totally different. About 30% thought the trials were unfair, 40% thought the judgments were too hard, and even 50% said the Allies dealt with the German war criminals in the wrong way. So what had happened in the meantime? Why did the situation change that fast? After the denazification process slowed down, we can observe a certain tendency to rather not think about the past and deny a responsible dealing with the Nazi regime. At the same time, foreign policy urged for a strong West Germany. It was meant to be a bulwark against communism. At the face of it, there were several legal points that were critically raised with a view to the Nuremberg trials. I'll pick out a few. First of all, the fairness of the trial. It was the Anglo-American criminal procedure that was implemented at the IMT in Nuremberg, and that was foreign to German lawyers. It was said that the defense lawyers couldn't cope with the adversarial structure of the proceedings. Against the overmighty prosecution means, the US team alone consisted of more than 200 members, the defense teams were totally helpless. Well, this point maybe bears some value, but it's a structural problem of criminal trials altogether. And if I may add, the discrepancy in means between the prosecution on the one hand and the defense on the other seems much bigger in the continental inquisitorial trial system than in the Anglo-American adversarial trial system. The former point, however, that the American procedure was foreign to the German defense lawyers, I don't think we can keep it up. According to my opinion, and Henry King agreed on this point as far as I understood him earlier today, the German defense lawyers were quite clever in using what their procedural means, and they used, for example, cross-examination features just as well. Although one might say that in particular the cross-examination backfired onto the defense dramatically when the defense called Rudolf Höss into the witness box, the book of which we are receiving in a minute. A second point is the difference between military and political issues. The criticism of the Nuremberg trials stretches to the question of whether a military leader can be held responsible for political decisions. The defense at Nuremberg, and in particular Professor Hermann Jarreis, who was defense lawyer for the accused Alfred Jodl, commander-in-chief of the German Wehrmacht. Again, we had already heard some points on this by Henry King earlier today. Hermann Jarreis pleaded that military leaders pursued orders, but the military leader is not responsible for the political decision to go to war. We have great military virtues in the German language. They are termed Treue and Ehre. They mean something like trustworthiness and honor. The discussion about these goes on. One might say maybe the discussion is a bit old-fashioned, but even now it's very vital in Germany and has reached a late peak when in 1995 the Hamburg Institute for Social Sciences sponsored a research into the crimes of the Wehrmacht, of the German army, which was called the War of Destruction, 1941 to 1944. That caused a major uproar in the German society because the legacy of a sort of lawful and pure German army, the Wehrmacht, was virtually destroyed by this research. Treue und Ehre, trustworthiness and honor, are terms that have been perverted. These positive images have been perverted by the Nazis once and more. Just recently, Richard von Schirach, who is the youngest son of Baldur von Schirach, who was sentenced at the IMT in Nuremberg to 20 years imprisonment, he wrote his memoirs just a couple of months ago. They were released in German. And Baldur von Schirach was also one of the persons who pointed out that they had sworn an oath, and they had to follow this oath. His son, Richard von Schirach, pointed later, as he was relieved, out to him that he could have resisted. And he told an interesting story. He referred to a novel by Theodor Fontane, which is called Wanderungen durch die Markt Brandenburg. In this novel, you have a protagonist. He's a Prussian general. His name was Count von Marwitz. He was a Prussian general, and he refused to fulfill orders by the king, orders that would amount to war crimes. He was dismissed from duty because of this. So Theodor Fontane takes up this story, and then he writes, the nephew of this Prussian general put on the gravestone of this person the words, he chose disobedience, where obedience would have brought shame. One would think that the very literate Baldur von Schirach knew this figure and this novel. And when Richard pointed out to him, there is someone who resisted, and there are examples in literature of people who resisted, why haven't you? Baldur von Schirach remained silent. Maybe the most important issue in these critical issues was the ex post facto law complaint, the violation of the principle nullum crimen sine lege, the principle of non-retroactivity. The claim that the Nuremberg trial violated this principle pertains in particular to the crime against peace. The other crimes, like war crimes and crimes against humanity, are in truth relatively unproblematic as concerns the principle of non-retroactivity. Informed people know this. For the general public, however, the entire prosecution was a violation of this principle. Notwithstanding Hans Kelsen's claim that this principle doesn't exist at all in international criminal law, the West German state put the principle at a highly prominent place in its constitution. In Article 103, paragraph 2, it says, nobody shall be held liable for a crime that wasn't a crime at the time the act was committed. Rightly so, I might say. This principle is essential for the rule of law, for the Rechtsstaat, as the Germans say. But sometimes I have the impression that this principle is carried as a categorical icon, misused to excuse highly immoral acts for formal reasons. Formality is in all a great tool to prevent effective prosecution and most appreciated by German lawyers, as we will see later on. The European Convention on Human Rights, an extremely successful instrument in the promotion of the rule of law and the respect for human rights in Europe, now stretching far into Eastern Europe and even into Turkey. And we've heard also by Henry King that also this is part of the legacy, this document is part of the legacy of Nuremberg. When it was drafted in 1950, the principle of non-retroactivity was inserted into Article 7. And because of this, the Nuremberg trials were so vivid, the memory was so vivid, there was an exception implemented in Article 7, paragraph 2, for the most heinous atrocities which violate the conscience of humanity. The young West German democracy was cautious enough to implement a reservation to this exception. And this was done despite the fact that Gustav Radbruch, the pre-Nazi German Reichsminister for Justice, claimed that highly unjust laws cannot justify criminal acts. This reservation is a clear and unequivocal sign of mistrust against Nuremberg. And up until today, Germany has not revoked this reservation, formally at least, but I'll come back to this point. Another issue which seems very important to me is the issue of the German victims. This is another flaw that was seen that in the Nuremberg trials, the German victims were in fact not included. True, the Allies were mostly interested in prosecuting the major war criminals for the atrocities which they committed on their territory or for the war that they've started. On the other hand, Justice Jackson tried to establish a broad crime of conspiracy which would have comprised all of this, all of the crimes against the German people as well. But he didn't succeed in the pre-Nuremberg diplomatic struggle to draft a statute for the IMT. It remains a pity, and maybe I'm a bit in conflict here with Mandel and Maris who spoke this morning. It remains a pity that the persecution of the Jews and other minorities living in Germany was not made a topic at Nuremberg. We still stand now in shock at this terrible loss. Through the Holocaust, my dear friends here, Germans eliminated the most talented, musical, artistic and literate part of its population. Sometimes we don't express enough how much we miss them. This is a number of arguments, a random number of arguments that were and still are brought forward to criticize the trials at Nuremberg. So couldn't maybe then the judicial system in Germany pick up these flaws and make it all better? But the truth is, when we look at the prosecutions of Nazis in West Germany after 1950, one cannot help but blushing in shame. Most of the proceedings that were taking place were carried by a strong sense of self-justification and mild understanding for the criminals. Whereas some of the most brutal SS murderers were convicted and sentenced, those who were responsible for planning and ordering the Holocaust behind their clean desks were left off the hook. The German High Court of Justice achieved this by following a strict subjective approach towards acting and abetting in crime. The outcome is as follows. The Führer, together with his gang, like Himmler and Heinrich, he is the person who is criminally responsible. He wanted the death of millions of Jews. Every member of his administration, for example in the Reichssicherheitsamt, the Office for Home Security, can only be prosecuted for abetting in murder. Of course, aiding and abetting is still a crime, but its sentence is much more lenient. The same is to be said of the prosecution of former Nazi judges. There is a crime in the German Criminal Code of perversion of justice, which means that judges can be held responsible for handing down arbitrary judgments. Also here, the post-1950 jurisprudence of the High Court of Justice in Germany adopted an extreme subjective approach. At the end, those judges who with full force were flexing and bending the law in order to bring Nazi ideology and politics to reality, who sentenced to death thousands of innocent victims in blatant breach of any known legal methodology, were freed and acquitted because they didn't act arbitrarily, but in accordance with their convictions, believing to fulfill the law, i.e. the Führer's will. I will spare myself any comment on this. However, criminal prosecution did have an impact on the German society. In particular, the so-called Auschwitz trial caused great distress. The then General Attorney of the state of Hesse, Fritz Bauer, who was of Jewish origin and survived the Nazi regime in exile in Scandinavia, initiated a trial against 20 Auschwitz perpetrators from guards to commander in 1963. This trial lasted for 2 years and received an extremely good media attention. It was mainly by this coverage that Germany finally was publicly shown what had really happened at Auschwitz. This brings the commentator Professor Micha Brumlik to conclude what the West German society has put aside, what politics couldn't do, what historical science was neither willing nor able to do, to investigate the systematic mass murder committed by Germans. This was done by the courts. Nevertheless, the overall outcome of this trial fits into the general trend. Rebecca Whitman rightly observes, the German public learned to chastise and denounce the sadistic excess perpetrator of Auschwitz and to forgive the order followers. But how was this possible? How could the German people in all be so ready to exonerate? What was the moral sentiment? Was there no moral sentiment of sorrow? Was there no collective grief? Germany experienced a total breakdown on May the 8th, 1945. However, due to political necessity, West Germany, as I already said, needed to be brought back to some strength because it was there where the border between the Western and the Eastern Bloc would be. A swift refurnishing was the consequence. But where would you get the personnel? Where would be the people to occupy the posts of the new German jurisdiction? The new German judge was supposed to be anti or at least non-Nazi. It might be ironic or tragic at the same time, but German society in all was so much infiltrated with National Socialism, it was simply impossible to find enough people. One would have to wait for an entire new generation. In the end, too many former obedient Nazi judges were taken over to serve as democratic judges after they had carried out, supported actively or tolerated the Nazi ideology for 12 years. In some regions of Germany, all of the pre-1945 judges kept their posts or were reintroduced into the judiciary. What do you expect from such a judiciary? Psychologically, I quite understand that they tried to exonerate Nazi criminals. By this, they exonerated themselves. The more understanding they showed in the trials against former Nazis, the better the light would be in which they stood themselves. It's hard to be called to judge as an outsider if, in truth, you are much more of an insider. It's always hard to judge on your own past, and that's exactly what they were called upon to do. In the Soviet-occupied zones, just a couple of sentences on this, which became later the German Democratic Republic, there was a different story. The socialist system that was established there claimed to be founded on anti-fascism. It started out to prosecute former Nazi war criminals, but soon the shadow of a new suppressive system, this time the socialist system, lay over any genuine attempt to come to terms with the past. Trials were utilized by the Party of the Socialist Unity to get rid of persons who were unwilling to cooperate with it. The socialist state proclaimed that it did not succeed in the German Reich and rejected any responsibility originating in the mass atrocities committed by the Nazis and their followers. West Germany was the fascist state that had to bear all of the responsibility. It didn't take long for the Socialist Party in East Germany to establish a system which was just as repressive as was the Nazi secret police. And people lived with it for almost 40 years. But then a miracle happened. In a totally peaceful revolution, the East German population, usually, by the way, perceived as being rather phlegmatic, freed itself from the socialist burden. We are the people. We are the people is the sound of these words I can still hear in my ears. On November the 9th, 1989, the Berlin Wall broke down just as the former US president had called on Soviet President Gorbachev to do. In an extremely emotional time, Germany became a unified nation, and 45 years after the end of World War II, the 2+4 treaty is something like an actual peace treaty. But, ladies and gentlemen, unification brought something else. There it was again, the problem of how to deal with systematic crimes, with crimes ordered and promoted by the state, in particular in the so-called Mauerschützen cases, Mauerschützen, the killings for border trespassing. These cases became test cases for the criminal justice system in Germany. By what I have been telling you before about the disinclination of German judges to prosecute state-backed crimes, you'll be surprised to hear that the German judiciary all of a sudden proved totally able and apt to solve the legal issues it considered as a hindrance to prosecute in the decades before. Statutory limitations, not a problem. Not a problem because it starts to run from the Unity Day, October the 3rd, 1990. Retroactivity, not a problem, because any GDR, Eastern German law, that would justify killing at the border killing of the border trespasser would be void, because as a minor violation of a human right. Do we find a similar aspect of victor's justice, Siegerjustiz? When West Germany, on the victorious side of the Cold War, judged over East Germans? Even further, did the West German judiciary try to exonerate itself? The judiciary attempted to do good for the omissions regarding Nazi crimes? Then, of course, there was the horrible war in Europe in the 1990s. The incredible suffering amongst the civilian population with reports of crimes against humanity and genocide. The term ethnic cleansing was crafted to explain the atrocities on the territory of what used to be Yugoslavia. The UN Security Council decided, and it came as a surprise, to establish the Yugoslav Tribunal, the ICTY. It took up the idea of Nuremberg and set up an international tribunal to prosecute these crimes against so many innocent victims. Germany, as it were, stood right in the middle of it. Not few war criminals tried to escape from Yugoslavia and find a safe haven in Germany. Here, the German chief prosecutors reacted swiftly and charged these criminals with war crimes and genocide and brought them before German courts by virtue of the principle of universality. One of the first to be arrested and indicted actually was Duško Tadić, who was later requested by the ICTY and extradited, virtually on the eve of the day he was supposed to stand trial before the High Court of Bavaria. He was extradited to the UN Tribunal. I need to emphasize here that for Germany, extradition in this case was for constitutional reasons anything but an easy step. Several other Yugoslav war criminals were tried and convicted to several years of imprisonment by German courts. The case of Tadić, on the other hand, became the unwarranted test case for the Yugoslav Tribunal. All these questions, the question of jurisdiction, of retroactivity, and so forth, were raised at this very trial. And again, something remarkable happened. In Tadić, the appeals chamber, in its first ever decision of October 2nd, 1995, developed what was called by the German international criminal law professor Klaus Kress at Cologne University and one of the great protagonists of modern international criminal law in Germany, what he called the second generation of international crimes. With this term, he tries to grasp the shift away from an international criminal law that is applicable only to international armed conflicts to a wider scope of ambit. Since this decision, the concept of crimes against humanity and war crimes is in parts also applicable to purely internal conflicts. The appeals chamber in its decision refers to the Nuremberg judgment over and again in order to buttress its argument in favor of a wider scope of customary law for war crimes in internal conflicts. Under these circumstances, and let me quote what Klaus Kress said at the conference judging Nuremberg on July 19th this year. Therefore, a government that insists that the principle of non-retroactivity needs to be applied in full force to crucial cases in public international law too, would have had reasons to criticize the Tadić jurisprudence. At the very same conference, the German Undersecretary of Justice, Hans-Jörg Geiger, emphasized in his address the importance of the Tadić trial and the positive role Germany played in this trial. Now, these are different tunes. Germany shows a different attitude towards international criminal trials than before. And doesn't the reception of the Tadić trial imply a de facto revision of the reservation made to Article 7, Paragraph 2 of the European Convention on Human Rights, I've told you some minutes ago? In the discussions on establishing a permanent international criminal court, the German government is playing a proactive role. This is mostly due to Hans-Peter Cowell, who served at the legal department of the German Foreign Office and was personally committed to the idea of international justice. He convinced the German government that it was about time to step out of the shadow and actively promote the idea of an ICC, even though some international partners would not be as supportive. And it wasn't only the United States. France and the United Kingdom were quite critical at the very outset as well. At the Rome conference for the establishing of the ICC, the German delegation was present under its leader, Hans-Peter Cowell, with, believe it or not, Whitney Harris, Ben Ferencz, and Henry King, all of them prosecutors at Nuremberg, as counselors. The prosecutors and the victims of the Nuremberg trials working together with a strong wish to continue what was started at the Nuremberg trials in order to prevent future crimes. What more could we wish to be done to keep the legacy of Justice Jackson alive? Let me mention one more point. The new government, which came into power in 1998 under Chancellor Schröder and the Secretary of State Joschka Fischer, and at this very moment I don't know who on earth will be the Chancellor of Germany. But this is another topic. They supported the struggle for international criminal justice. Germany ratified the Rome Statute swiftly and passed a code of international crimes called Völkerstrafgesetzbuch, which can be seen as the most modern codification of substantive international criminal law and serve as a blueprint to many countries who want to amend the national laws so that they fit the Rome Statute's requirement of complementarity. Hans-Peter Cowell was elected the first German judge at the ICC. He is president of the pre-trial chamber and as such administering the first case at the ICC of the Darfur-Sudan region. Ladies and gentlemen, there is still a lot to be done. The German government is further working on the ICC issue. I myself am a member of a working commission of the Foreign Office on International Criminal Law, which is meant as an advisory committee to the government. Interestingly, though, the average age at this committee is maybe something like 38. There are many young German lawyers working at the international tribunals, at the International Prosecutor and the ICC. They are all Jackson followers, if you wish. Professor Albin Eser, the former director of the prestigious Max Planck Institute for Criminal Law in Germany and now ad litem judge at the Yugoslav Tribunal, admitted just recently in Nuremberg that in his work at the tribunal he encounters the Nuremberg trials on an everyday basis. A German judge using the Nuremberg judgment as a precedent, things have truly changed. But let me summarize the sentiments concerning international justice in the following way. I have the impression that Germans are totally unified in the efforts towards a working and effective international criminal court because they have learned one thing. For state-supported atrocities, national courts are not well chosen to prosecute. It needs an outside control by a complementary ICC, which stands ready to take over the prosecution if the national system fails. This is a necessary limit to state sovereignty. I want to close with a personal remark. Ladies and gentlemen, I was born in Germany in 1971, at a time when the stigmata of the war were mostly polished up. Germany was an occupied country, and I was told that the US soldiers which were stationed in my hometown were there in order to protect us against the Russians. As a boy, I have to say, I felt safe. It took a while until I realized that my country had done something very bad, something that nobody liked to talk about. In history class, when we were all around 15 years of age, we learned that what happened. We were taken to the concentration camp in Dachau to get a visual impression. Obviously, the presence of the US soldiers had something to do with that. Later, I went to study in Munich at the university, and at this university, the resistant group Die Weiße Rose, the White Rose, around the charismatic Sophie Scholl, they had become my heroes. These young people who sacrificed their lives for disobedience stand as a shining example that you always have a choice. No matter what the Nazi bosses said at Nuremberg, you have a choice. There is one more thing that I have come to appreciate more and more over this very special year of remembrance. Nuremberg is not only the birth of international criminal law. It was for me the beginning of democracy in Germany. If we base our society on human rights and on answering cruelties with the rule of law, this is a good basis. And let me say this here at the Jackson Center. My idea of democracy is shaped by Justice Jackson and by what he expressed in his opening speech in courtroom 600 in the Palace of Justice of Nuremberg. I'm proud of what he did, and I have no words strong enough to express my appreciation and thankfulness for what he did for me and for my country. Thank you for your attention.
Now we've got just a few minutes before the bus gears up and heads back. Chris has agreed to take on any questions that anybody may particularly have. Questions for Dr. Safferling about the German perspective on this? Nobody? Yes.
So here you talk about the role that judicial proceedings outside of Germany might have played in bringing about a reckoning, perhaps such as the Eichmann trial.
From the time that I personally sort of could have followed, I don't think that it had much of an impact on the people itself. It, of course, I mean, in the academic world, it was closely followed. It is taken as a precedent, and it, in particular, Hannah Arendt's book was widely read and appreciated.
The contemporaneous press, wasn't it quite dramatically focused on that trial?
Yeah, it did, but I can't see that. Like from my personal perspective, as a if you look at the impression that it had on society, I wouldn't say that it was that strong. It was much more of the Auschwitz trial. I think was much more important because it took place in Germany in a German courtroom, and overall what was happening in Israel was the whole idea of how Eichmann was brought to Israel and all that was maybe seen very critical because he was somehow snatched away by he didn't have a choice. He was taken hostage. That was maybe an idea that was around. And then again, it was this very Fritz Bauer, who was also sort of helpful in finding Eichmann and bringing him to Israel. But from my appreciation, I don't think that the Eichmann case in particular had a shocking effort on German society.
Do you think that the European community influenced Germany's position on the view of Nuremberg? Did it show the value of multilateralism versus unilateralism as had been carried out under Hitler? In other words, the value of cooperation, some limitations on sovereignty to assure the future and rule of law. Did that have any effect on the change in German opinion?
Yes, it did. I don't know what comes first, right? I have the impression that the German government was very, very ready from the very beginning on to have close ties with its Western allies. And Adenauer started out to be friendly with France and make close ties with that. And Germany was all too ready to do everything it could to have an outside control. That it would be safe situated in a European community, sort of to prevent through this that anything like another Nazi takeover could take place. I think there was a driving force of the German government in order to sort of bring the European unity forward. And I'm not so sure how much the rebound effect was, how big that was, because I think that Germany was very much the driving force behind the European unity, and not so much the European Union that was, that was forcing Germany to sort of give up sovereignty. Germany was all too willing to give it up itself. And you can see by the European Convention on Human Rights that Germany did that from the very beginning onwards, and very, apart from this retroactivity principle, it didn't make any reservations whatsoever. All the other countries, United Kingdom and France, they drafted reservations, and what Germany didn't. It sort of dewed itself to the jurisdiction of the court all too willingly. Any more questions?
Christoph, since you basically acknowledge that international criminal justice had its birthplace at Nuremberg, and the concept of international criminal justice grew up from Jackson's original blueprint. Do you ever privately have any thoughts about how ironic and inconsistent it is today for most of the world to be supporting the International Criminal Court, but the United States, from whence the concept came through Jackson, is still resisting with Archie Bunker logic and ill-conceived thoughts? I mean, could you be private with us and tell us what you think about it?
Yeah, I was afraid that such a question would bump up, and I'd have to sort of make a statement on the general sort of view on the relationship between Germany and the United States, and it's a difficult issue. It's a difficult issue for several reasons, and I think the ICC is not on the top of the agenda. It's much more the Iraq War, which the Germans don't understand and which they don't like, and everything that follows with the Guantanamo thing, and that's really what Germans don't understand, why the United States have do this, simply. The ICC, I think, I mean, I can tell you my personal opinion first, and I think that there are some people in Germany who think likewise. My opinion would be that it doesn't matter whether or not the United States are on board or not, for the time being. We have the chance to show them that it'll be a fine institution that'll do excellent work, and in particular that it is a reliable institution. I have the impression, following the discussion here a little bit, I have the impression, notwithstanding arguments that are being brought forward that are actually absolutely valid and that you have to discuss, and I understand a lot of constitutional reservations that some US lawyers, or maybe some more than just some, have, I can understand them. And, but we have to somehow come to a compromise. So we have to also, from my German criminal procedural perspective, we have to give up certain ideas, and we have a different procedural system, which is just not bad, not worse or better, than it's just a different system. So, but I think despite all these individual critical points that there are, I think at the bottom line, there is a matter of trust, that the United States are not willing to trust an outside and foreign power whatsoever. And this is what we have to prove, and the rest of us, who is sort of member state to the ICC, have to show that it is a reliable institution. It doesn't do any harm, and we have the principle of complementarity, and we will not abuse the principle of complementarity as long as you go ahead and keep your house clean and prosecute your criminals. The ICC will not intervene. These are the issues that we'll have to show. And I think that sooner or later, the ICC will convince the United States and government and its people that it is a reliable institution and that it's worth to cooperate, because you gain more than you lose by cooperating. And I think this view is shared by some of my German colleagues as well.
Thank you, Chris.